Hello, my name is Nicola and I'm a partner at Rahman Ravelli, and I'm going to be talking to you about private prosecutions. What are they and who can bring one? With international law enforcement agencies struggling to cope with increased and more sophisticated criminal activity, many victims may be choosing to pursue justice privately, and therefore the use of private prosecutions is certainly on the rise. A private prosecution involves an individual or company bringing criminal proceedings against another person or company where they consider themselves to be the victims of criminal acts committed against them by those persons. Typical examples of those offences would be theft or fraud. A private prosecution can be brought against overseas individuals and companies. Likewise, foreign companies and organisations can use the private prosecution process, provided that there is a UK connection to the alleged wrongdoing. A private prosecution is not brought by the Crown Prosecution Service or another prosecuting authority, such as the Serious Fraud Office or the National Crime Agency, but by private persons, and their right to do so is reserved under Section 6, Subsection 1 of the Prosecution of Offenders Act 1985. A private prosecution can be a quicker solution than relying on the police or other law enforcement agencies to investigate and/or prosecute suspected criminal activity. It can be a useful option where the authorities have declined to prosecute. Examples of this may be due to budget restraints or lack of resources to pursue the matter. A private prosecution will proceed, for all intents and purposes, like any other prosecution brought by the prosecution authorities. If a private prosecution leads to a conviction, the sentencing and confiscation stages are again conducted in the same way as if the case had been prosecuted by the CPS or the SFO, etc. It's important that anyone considering a private prosecution assesses whether bringing one is more appropriate than relying on the state agencies to prosecute. If the authorities are unable or unwilling to prosecute, then a person should also assess whether a private prosecution is a more effective way of seeking justice rather than bringing civil proceedings against the intended defendant. To be effective, a private prosecution needs to be managed by those relevant expertise and skills, as there are a number of legal considerations which need to be addressed and managed.
My name is Niall Hearty, a partner here at Rahman Ravelli Solicitors. Today I'm discussing the benefits of bringing a private prosecution and some legal considerations. If I may turn to the benefits first of all. Although every case is different, there can be distinct advantages to bringing a private prosecution. Bringing a private prosecution can be a quicker way of conducting or concluding a matter than waiting for the authorities to decide if they will investigate and then prosecute. Law enforcement agencies may lack the time, resources, or even the expertise to investigate your complaint. Bringing a private prosecution ensures that the matter concerned is a priority, with you determining its pace, helping shape the course of it, and identifying the issues and the evidence. Regardless of the outcome of a private prosecution, the costs, or at least some of them, can be recovered from the state under Section 17 of the Prosecution of Offenders Act. This can mean that a private prosecution is a cost-effective option for an individual or company that wishes to see justice done but has a limited budget. If a private prosecution is successful, it is possible to request the court makes a confiscation order as well as a compensation order to ensure that any losses incurred by the crime are repaid. And finally, when a private prosecution both by an individual or company results in a conviction, it can send out a very strong deterrent message to anyone that may be considered similar wrongdoing. If I can now turn to the legal considerations. There are a number of important issues to consider when deciding to bring a prosecution. They are disclosure. Private prosecutors have a duty to comply with the disclosure principles under the Criminal Procedure and Investigations Act 1996. This means they must record and retain all relevant material which does not form part of the prosecution evidence in the case. Any material that undermines the prosecution case or assists the defence has to be given to the defence to ensure proceedings are conducted fairly. Failure to do this can lead to a prosecution failing because there has been what is regarded as an abuse of the court process. Assembling the evidence. The strength of a private prosecution depends to a great extent on the quality of the evidence available, which has to be obtained by those bringing the private prosecution. Evidence can include witness statements from all relevant individuals, documentation, data, and any other items that relate to the allegations. Witness statements that form part of the prosecution case must be served on the defendant once proceedings has begun. The Bankers' Books Evidence Act 1879 covers the use of bank records and can be a way of obtaining potentially evidential material for any private prosecution. Although much material is publicly available, some material gathered for private prosecution may be subject to legal professional privilege, such as correspondence between a lawyer and a client. Certain rules have to be followed in relation to such evidence, and it should be noted that parts of the Data Protection Act 1998 will be relevant when it comes to obtaining certain types of material, such as that held by banks or indeed by the police. If a third party is unwilling to provide information due to exemptions in the Data Protection Act, the person seeking it or the person seeking to bring the private prosecution may apply for a Norwich pharmaceutical order. Such an order, named after the case that established the principle, can compel any third party innocently involved in the wrongdoing to disclose particular information or documents. The full code test. When considering whether to bring a private prosecution, the person intending to bring it should apply what is known as the full code test. This test is contained in the code for the Crown prosecutors and sets out the principles to be applied when deciding whether a case should be prosecuted or not. This involves considering, first question, is there sufficient evidence to provide a realistic prospect of conviction? If the answer is yes, then the next question is the prosecution required in the public interest? The application of these criteria requires skilled and detailed analysis of the evidence available. No two cases will be identical, and each will require careful scrutiny in order to determine whether it meets the requirements of the test. And finally, restraint orders. A restraint order may need to be applied to freeze the assets of the person being prosecuted if there is a risk that that person may spend, squander, or relocate their assets before the prosecution has concluded. Under Section 40, subsection 2 and 41 of the Proceeds of Crime Act 2002, the Crown Court can make a restraint order preventing any specified person dealing with any realisable property if a criminal investigation has been started.
My name is Zulfi Meerza, and I'm a Senior Associate at Rahman Ravelli Solicitors, and I will be talking you through the process of bringing a private prosecution. So there's a number of factors or points to consider when bringing a private prosecution. But prior to even instituting the proceedings, there are a few things to bear in mind. One is that a private prosecutor and his or her legal team must be satisfied that the facts alleged amount to a prima facie case, and those facts are or will be supported by evidence. So whilst there's no legal requirement for a private prosecution to satisfy the full code test, it is considered best practice for private prosecutors and those who advise them to apply the full code test before commencing proceedings. Now, what is the full code test? You'd have probably heard about this earlier, but I'll just briefly go over this. The code test means that the private prosecutor must be satisfied that there is sufficient evidence to provide a realistic prospect of conviction against each defendant on each charge, and that the prosecution is in the public interest. So before even commencing proceedings, it is good practice to apply the full code test as a starting point. Now actually coming to instituting the proceedings, if a person wishes to bring a private prosecution, they may institute the proceedings by either charge or summons. Charge tends to be if you have established relationships with law enforcement agencies. But in terms of private prosecutions, the majority of private prosecutions will commence via an application for a summons. and that is usually done in the magistrate's court. The court will then decide whether to actually issue a summons, which will require the defendant to attend court on a certain date. Now, in terms of making an application for a summons, there are a number of factors to consider. I'll take you through these now and highlight the sort of really important one that you'll need to consider. But first of all, in terms of applying for a summons, the applicant must comply with the requirements of Part 7 of the Criminal Procedure Rules. Now, this includes various factors. For example, the application should set out the allegations against each defendant, and the application is usually accompanied by a schedule of draft charges. Now, these criminal procedure rules have been updated as of the 3rd of October 2022, and there are specific inclusions in relation to private prosecutions, which I will come on to shortly. But generally, the application should comply with Part 7 of the Criminal Procedure Rules. Secondly, the application should include any formal responses of the defendant to the allegations. For example, if there's any sort of statement in relation to the charges, either within an interview that was done on a voluntary basis, or representations provided in another format, then those should be put in front of the court as part of the application. Thirdly, skeleton arguments should be included. This is usually done if an application is, or if there is a need in the application to consider legal arguments at an early stage. Then skeleton arguments should be included within the summons application. Fourthly, there's a new requirement as part of Rule 7.4 of the updated criminal procedure rules that every application for a summons should properly identify the prosecutor so that the defendant could, if they wished, oppose the continuation of the proceedings in the court or invite the Director of Public Prosecutions to intervene, or both. So as you can see, this is one of the amendments or specific inclusions in relation to private prosecutions that was introduced by the updated criminal procedure rules. The next sort of factor to consider when making an application is venue. Here, this is important in identifying the appropriate court at which to apply for a summons. Usually the factors to consider when determining venue are the location of the offence, the location of the victims and or witnesses, and also the location of any defendants. Lastly, and probably most important, is the duty of candor. And when making an application here, any material that is potentially adverse to the application should be provided with it. This is to ensure that the court has all the relevant information in front of them in order to make a determination on the application, and also to ensure fairness in the proceedings or in the decision-making process of the court, because more often than not, applications for summons are made ex parte. So, for example, this could include, as mentioned earlier, any formal responses that the defendant has provided in relation to the allegation, and also could include reasons given by any prosecuting authority for not accepting a case if an approach was actually made to them in the first place. So really the points there are to do with providing the court with anything that could potentially undermine the application for a summons, or assist the defendant in relation to their objections to an application for a summons. And the real crux of it is to make sure that the court are in a position to decide on the application fairly. The next point I want to move on to is the court's refusal to issue a summons. Now, the updated criminal procedure rules, Rule 7.2, provides a number of circumstances where a court may decline to issue a summons. Now, there are a number of points here to consider, but I'll just go through a couple. For example, one factor which is important is that if the prosecutor fails to disclose all information that is material to what the court must decide, then that is a circumstance in which the court may refuse to issue a summons. Again, this goes back to the point about duty of candor and making sure the court has all relevant information in front of them when making a determination on the application. Secondly, the prosecutor's dominant motive may render the prosecution an abuse of process of the court. So really the important question here for the court is whether a prosecutor is using the criminal proceedings as a means of establishing and punishing criminal conduct, or is the prosecutor in truth using the proceedings for some other purpose? And this really goes down to the point about dominant motive and if the prosecutor is using the application for a purpose which is not a proper purpose. The next point to consider is the position of the Director of Public Prosecutions and or the CPS. Now here there's quite a few factors to consider here and generally quite a few moving parts. The first is that unless an offence requires the consent of the DPP or the Attorney General, for example, offences under the Bribery Act 2010, in which case the CPS would take over conduct of the case if consent is given, there is actually no obligation on a private prosecutor to notify the DPP or the CPS that they are contemplating or have actually commenced proceedings for a private prosecution. However, it should be noted that the DPP under Section 6.2 of the Prosecution of Offences Act 1985 has the power to take over a private prosecution. In addition, if the case meets the code test, which is, as mentioned earlier, best practice for the prosecutor to consider in advance of instituting the proceedings, the CPS has a discretion on whether to take the case over or allow the private prosecution to continue. In addition, a private prosecutor may also wish to make representations to the CPS as to whether the DPP should exercise their powers and take the case over. So as you can see, there are quite a few moving parts to consider here in relation to a private prosecution. And there are a number of points at which the DPP and or the CPS can intervene if it's right to do so. The last point I want to come on to in relation to the process of bringing a private prosecution very briefly is in relation to the decision on granting bail. Here, the prosecution should be in a position to provide sufficient information to allow the court to make a decision as to whether or not to grant bail. This will include a number of factors in the same way as if the Crown is bringing a prosecution. And for example, will include the obtaining of the PNC of any defendants, which will contain any details as to their criminal record, if any. Now, in a private prosecution, this is not usually given by the police to the prosecutor, in which case the private prosecutor would have to apply to the court to be able to obtain the PNC. I think that's the main point I want to discuss in terms of bail, but the key takeaway point in relation to the process of bringing a private prosecution is for all intents and purposes, it is done in really the same way as if a prosecution is brought by the state, and all the rules should be adhered to by a private prosecutor to ensure that the process is conducted fairly and properly, and therefore that would minimize the chances of an abuse argument being raised at an early stage.